Good evening to everyone, and especially I welcome the foreign attorneys who have come all the way taking pain to this place. And this is first of all, let me thank the event organizers for bringing the awareness of this program about the different laws in different countries and to know about the procedural aspects. And I am told that I will be given only 15 minutes time, and I will stick to that. And now this is the here where earlier one of the speaker, Mr. Mustafa Safiuddinji, was talking about the laws and the approach of the judiciary in the two different courts, Bombay and Delhi. At least I am not on that part, because law of the land has to be followed by everyone, let it be Bombay court or High Court of Delhi, or if it is the Supreme Court, everybody is binding. Some of the landmark and major judgments so far it is been rendered in with regard to the trademark will be discussed in the slides. But interestingly, the theme of this topic is given as a trademark and brand equity. I thought it's my endeavor to at least look into what is the brand equity, how the brands are evaluated, and how the brand can be developed. The reason being because the damages or subsequently well-known trademark concept has to be decided by the courts on the issue of what is the brand equity. Now, it's not the fundamentals we are teaching about what is brand equity and the brand progression and all. When the brand starts, nobody may think that this brand becomes so famous. When the brand becomes so famous, people will try to imitate. There the question of infringement and passing of all these things arises. But the brand, once it is started at the initial stage, it should have the acceptability of the people. Then only the brand becomes very famous. And in order to get the acceptability of the people, we should bring the awareness of the brand. Probably awareness could be by way of advertisements, and most importantly, you have to maintain the quality. And quality and promotion, when both goes in parallel, the brand becomes famous. When the brand becomes famous, naturally litigation starts. The people will try to imitate that. I don't say whether in India people are called as very good in reverse engineering or imitating. I don't say that. But the kind of the judgments are coming up now, the judiciary is very well updated with the latest trends in the law. Law is dynamic, it's evolving. And thank God the conferences and seminars like this are bringing more awareness. But my personal opinion is that even judiciary should also be brought to these forums so that they should understand what are the developments in different countries, in the different courts in India. That's my personal view. And why this brand is so famous now? The second is the value of the brands and the overall value of the company. If you look into the slide, the last one in the 2010, if you look into that, the kind of the property, the value of the intangible property, probably at least in India, if I'm not aware about the abroad, but in India we give so much of importance to tangible properties. We purchase the properties, plots, flats, or real estate, but very few people were known to purchasing the intangible property and investing into that. And recent trends as an upcoming advocates like the firms like us, we face a lot of problem to evaluate the brand value. Especially I quote one example with regard to one of the company which was in the debts, especially in Hyderabad, is a Deccan Chronicle newspaper. The question arises, when all the values of the real estate properties and tangible properties are seized by the bank, the question arises, what could be the value of the brand so that can be paid to the banks? Then there was a lot of issue. Who will evaluate it? Who are the competent person to evaluate the brand? And what are the methodology to be adapted to the evaluation? So accordingly, the value of the brand, if you look into the diagram, the intangible property has become so famous nowadays, and future is going to be definitely the title given to this particular seminar or conference is Gateway to Growth and Value of IP. It's really interesting. Now, look into first of all, how to promote a brand. Normally, the brand does not look just like that. You take any brand, even the question of the law firms, so far so many law firms have come up. These firms are not successful just because of that. It's not that you participate in the seminar, you get a client and you prove your quality. No. You have to maintain, you have to get the results, you have to work hard. Then the brand becomes famous and the clients and customers will get acquainted with this. They are assured with the quality, they are assured with the results. Then brand becomes famous. So first and foremost, my personal view is that a quality of the product, maybe it is a service or a product, you need to maintain. And of course, you may be extraordinarily brilliant unless you advertise yourself. people may not be knowing, even if it is with the product also. You've got a wonderful product, but still if you don't advertise it, public may not be aware of it. And at the same time, there are several products I see in the market. Take the example of water. A water is filled up in the Bisleri bottle, and there is a one bottle called, I have seen in the most of the airports and all, Aqua. And same water, if you put it in the same bottle, same quantity, you pay more. Why? Because the ambience, appearance it looks like. That is also important. Interestingly, design is one more intellectual property right. And most of the products, you take the vehicles also. There are engines, every engine performs, motor vehicles. But the brand name, the shape it looks like, that matters to the product. So every product of such has got the intellectual property, all intellectual property rights. If your label is not presented good, a copyright, even that product does not click. And trademark is the only one issue of the intellectual property for every product. When you take the quality of the drink you take as a Coca-Cola or Thumbs Up or anything, the ingredient of the product which matters may be a patentable matter, how they mix up the different ingredients, get the output. So accordingly, apart from that, the taglines are important aspect nowadays. Some of the taglines, at least I am passionate with the tagline of one of the adhesive, which is Fevicol, if I am not wrong. They say that you can join everything except the broken hearts. It looks very interesting. So, but the management and the people who are thinking, giving these taglines, there are several hundreds of people are working to create the tagline. So these are all amount which goes into the intellectual property to promote your brand. And when brand becomes famous, and believe me, the litigation is one of the toughest tasks. Filing of the application, getting the registration, all these are very easy. Unless you have got a very good counsel or very good person who is very acquainted with the IPR matters, you won't get the results what maybe the judiciary is there. Now some of the taglines I just picked up for the understanding. See, some of the HSBC is the world's local bank. They put as a tagline. McDonald's, I am loving it. KFC, so good. High performance delivered for the Accenture. Bridgestone, your journey, our passion. The power of dreams of the Honda. Quality revolution of Toyota. And sheer driving pleasure of BMW. These are some of the taglines which have become very famous. And there are several other taglines. So in order to promote a product, you should have a better tagline also. Now evaluation of the brand, as I was discussing, because what is that brand, how you can say. I read in the newspaper a few months back saying that Apple brand is worth of $100 billion. $100 million, I'm not able to exactly put it out, $118 million if I'm not wrong. But who will decide this? What is the brand value? Suppose if I want to purchase an Apple brand, will they get it for $118 billion? It's not the bricks or mortar or the equipment or the personnel working there. It's not the company I'm purchasing. It's a brand just cost like that. So preferably when the matter comes to the court, because we are thinking of discussing the slides with regard to the litigation and the approach of the judiciary. And when you say that Apple is a well-known brand, without projecting your sales figures, without projecting your transborder reputation, without projecting your documents, it is very difficult for the judge to understand what is a well-known trademark. So first of all, company should have to maintain the accounts. And these accounts and the results and whatever the value of the brand could have been reflected in the balance sheets. That is the most authenticated document which can give the value to the brand, which can be understood that it is a famous brand. Now, apart from that, there are lots of assignments and licensing are happening. Had an occasion to listen to some of the seminars of the Microsoft person who is representing. They are only into licensing and assigning the brands. Believe me, on licensing, the billions, millions and billions dollars are being earned. That gives the evaluation of the brand, despite of the several organizations, third-party organizations which are evaluating the brand value, but these are the statutory documents where you are paying some fees to the government. That could be the most appropriate document to evaluate the brand value when the litigation comes up. And third-party surveys, when the litigation comes up, either of the party, plaintiff and defendant, files the documents, third-party surveys, but what is authenticated? What is the acceptability of those documents in the evidence? That's the problem. And mortgaging with the banks also gives a right value to the banks. And when the banks can lend the loans to the intangible property, that court believes that this is the worth of the brand. And IP evaluators, chartered accountants, lot many organizations. I had an occasion to listen to some of the organizations like American Appraisal and some other organizations which are giving that they are the brand evaluators. But the question comes, what is the authenticity of those documents which can be taken to the courts? Now, This is some of the statistics I could get it before you. The brand value of the Apple is $118,000 million. And these are in the seriatim. It's a Google, second topmost brand, Microsoft, Amazon, Honda, SAP, Facebook, Volkswagen, Audi, and Xerox. And I got a very fascinating, with regard to the Xerox. Believe me, show me any one shop in the India saying that it is written that it is a photocopy shop. Everybody writes it's a Xerox shop. Some people even fascinate me, give me a Modi Xerox. Nothing like Modi Xerox. And Modi and Xerox both are in similar business. Machine is a Modi, but Xerox is also a company which do that process. Now Xerox, exactly. Now Xerox has become synonym to photocopying. So that is the brand value. That what is the brand which we are looking for. When you approach to the code, you should be able to establish before the code that how big value your brand is. And one of the Indian famous product, can you name it? Dalda. Dalda itself is a brand. People say, give me so and so Dalda. Nothing like that. So that's how the brand, when brand becomes famous, and people really imitate that. And as a councils, when you argue before the courts, it becomes very tough to establish what is a well-known trademark and what is not well-known. Now, how to protect the brands? Because this is, before going to the litigation, these are the documents, especially for the, with great respect to the attorneys from the abroad foreign countries. When they file their suits in India, has a defendant counsel where I got a better experience? What are the lacunas in the documents filed before the court? What are the lacunas in the pleadings taken by the plaintiff? Then where we exploit and where most of the cases defendants won against the plaintiff also. First and foremost is all intellectual property rights. Everybody agrees with me. Is the prior user is the most important. Even if the brand is not registered, if the person is able to establish before the court of law that he is a prior user, then he has got a better case. Sometimes better than the registered brand. And second, of course, a statutory right which is like trademark and registration under Trademark and Copyright Act, which gives a statutory value. It is something like when the Indians only register their marriages when they go abroad to United States of America because embassy wants this. So accordingly, the brand registration is, it will ease the process to establish before the courts to say that this is a registered brand. I'm not going to the specific case of the sections of the act which says that once registration is there, it itself gives the evidential value and it has to be, any infringement should be ordered to be given in favor of the plaintiff. And there are several cases where the brands are registered but renewals are not done. And that also weakens the case. And caution notices, which I personally feel that multinational companies keep on giving some of the caution notice in the newspapers and publications in order to protect the brand, to say that despite of our warning into the general public at large, the defendant has infringed in this brand. That gives one of the major defense and support to the case of the plaintiff. And filing of the oppositions against imitating brands. There should be a counsel, maybe in-house counsel or the attorneys who are engaged. They should be keep on tracking of the imitating brands, where the brands when come up in the trademark journal, it should be opposed. And filing of the suits of infringement and passing, of course, this is the whole purpose of this slide. And availing the criminal remedies is one of the other benefit we have got it. Now, what are the procedural considerations in filing of the suits? And with great respect, one of the speaker was discussing about the section 134. I got the different opinion on that. Because section 134 is completely contrary to the view taken by the Civil Procedure Code with regard to jurisdiction and cause of action. As per the Civil Procedure Code, wherever the defendant resides or defendant violates the rights, you can file a suit. But it is a special act. The courts have held in Doda House case and other Indian performance rights case, and so many judgments have come up so far, and still something has to come out from the Honorable Supreme Court. Still every attorney in India is waiting for that. Now section 134, as long as it is there, so wherever the plaintiff resides partly or fully, even some of the judgments which my learned friend has preferred in this with regard to internet access and all. So still the law is not perfectly laid down, that is yet to be weighted. And cause of action, where the damages is being occurred, but this is one of the issue which has to be looked into consideration. And most important thing, most of the companies neglect is delay, latches and acquiescence. That is with regard to, suppose you issue a notice to defendant or the person who is violating your rights. And it's not the end of the story. Once you give a notice, your action for the infringement has started. Even though you get a reply or without getting a reply also, you can file a suit without any possible delay, which could not be a ground for defendant subsequent stages. Even after 1 year of delay of issuing a notice also goes against the plaintiff. There are several judgments, we'll discuss on that. And claiming of the damages, with great respect, the counsel sitting from all over all parts of India, and especially when the suits are filed, so-called the jurisdiction with regard to the pecuniary jurisdictions, had an occasion to argue the matters as against the pecuniary jurisdiction. There were the cases filed claiming the damages 20 lakhs 5,000. Just because Delhi High Court jurisdiction is a minimum 20 lakhs. I'm not disputing that, because that becomes one of the ground for the defendant. Believe me, there is an occasion where I'm not quoting the examples, but I'm not quoting the judgments. But occasion we argue the matter, suit itself is dismissed on the pecuniary jurisdiction. It could be 21, 22, 23, even 50 lakhs. Now I don't know whether right or wrong, but counsels from Delhi can update me on this, because there is a jurisdiction now, it is increased to 2 crores. It is in the plan now. I don't know whether it has happened or happening. No, these are the precautions should be taken when the company needs to file as a plaintiff in any of the courts. Just even the notional damages can be claimed in the injunction, but at least to stick on to some sense of this thing, experience, back experience, saying that it cannot be 20 lakhs 5,000 at least. And relevant documents. And most of the cases I see, especially Trademark Act certificates, when you file the certificate, you file a registration certificate. But hardly some of the counsels, most of the people do not file a certificate for legal proceedings. That becomes a defendant, again defendant's placed with that particular issue, and it becomes a point for the defendant to defeat the case of the plaintiff. And suppression of the facts, of course, every courts in the world, especially with regard in India, Supreme Court has given the landmark judgment in Chengalvaraidu case, where any person approaches the court by suppressing the facts and misrepresenting, and with unclean hands, if he approaches the court, he should be thrown out of the court. So these precautions should be taken. All the facts should be given to the courts, and especially then only you will get the ex parte order. And I will discuss about the next slides about the ex parte orders. Sure, sir, I got 5 more minutes. Fine. My friends should cooperate. Fine. Now, with this coming to what are the remedies available? I'm not giving a lecture on the remedies, what are the remedies, what not, and all. But issue is, with regard to the most of the thrill, every counsel agrees with me, is thrill in getting the ex parte orders. But I slightly differ with this. It's not that I am telling the Delhi court, Bombay court. I am from Hyderabad. I have no way concerned with any of the courts here. But still, the problem is, Civil Procedure Code very clearly says, whenever the ex parte order is given, it has to be discussed and decided within 30 days as per Order 39, Rule 3A. This I strongly have got my personal view on this. Yes, there are the cases. Suppose if I file a copyright case before the court, I file a case on Wednesday or Thursday, and Friday the picture is going to be released with regard to the particular film which I am challenging. Once the picture is released, nothing remains. Under those circumstances, ex parte orders can be given. Order 39, Rule 1 and 2 of the CPC, Civil Procedure Code, clearly says that whenever there is a prima facie case, balance of convenience, and irreparable loss, then definitely court should rescue the person who is approaching the courts with prima facie case. But there are the cases, suppose I am violating, somebody is infringing the brand which is not identical but maybe deceptive similar. But what could be the damages could happen within 1 month notice is given to the person? Because once defendant's brand is closed, once company is closed, the whole company comes to the on the roads. And vacating the ex parte orders is a very tough time. Everybody will agree with me here. Maybe a part of Delhi, maybe a part of Bombay. I am not on that point. Let it be the courts functioning. Now courts are dynamic now. Several judgments have come up. Judgments are given either way. I can assure you that a clever advocate can argue for plaintiff as well as defendant. He can win for both. The judgments are either way. How you interpret. That is your caliber. That's how you become a famous in this legal fraternity. Now, coming to the Anton Pillar order and Mareva injunction and John Doe order, everybody is aware. I am not going to explain on that point. But there are the cases. Even if I get an ex parte order, the moment I reach to the defendant place, there is every possibility. Suppose with regard to software program, a Microsoft software program, somebody is copying. The person gets information that the moment the court order reaches to his premises, he may destroy whole evidence. Under those circumstances, courts can rescue by giving the Anton Pillar order or Mareva injunction or John Doe order. In John Doe order also, because where some of the cases where the defendant may not be a party, and court can give such an order where you can inspect any of the premises. Some of the judgments with regard to the Taj television versus in the football issue, football World Cup issue, the court has given such an order. And appointment of advocate commissioner to inspect the premises of the defendant to know what is happening. With regard to damages and compensatory and punitive, I'll discuss in the next slide. This is approach of the judiciary, where actually this is the topic which I am intended to do, because in order to get to this subject, I was to tell all these things. Now, issue is the lack of knowledge. With great respect, nobody can be perfect, no counsel can be perfect in all the subjects. And IPR itself is not a subject, it is correlated to several other subjects, criminal procedure code as well as civil procedure code. And judges are overburdened with several other litigations, and most of the judges, with great respect, may not be aware of this subject, IPR. There could be a seminars like this. I really appreciate if the GIPC can take up some of the judiciary can also be called for this, to share the views of the different countries and the different orders in different courts all through the world. And lack of that awareness should come to the among the judiciary. And Article 39, Rule 1 and 2, I discussed with regard to the prima facie case, balance of convenience and irreparable loss. And awarding the damages 2005 onwards, Indian judiciary with regard to the IPR matters started giving the punitive damages and compensatory damages. That is a very good thing. And also, with great respect, the plaintiff who approached the court with unclean hands are also being punished for filing a frivolous suit. This either way, it shows that it gives an indication to the whole world. Yes, Indian judiciary has come up with this. Indian judiciary is evolving now with regard to IPR subject matter. That's what we are discussing in all these forums. And of course, ex parte orders, there are different views. Orders on equity. In the recent part, very latest judgment with regard to Bristol-Myers versus Milan Laboratories. The court has given the order on equity. Equity in the sense that was a drug which is to be used for the AIDS people to be exported to the Venezuela. Court held that let the defendant send the goods by depositing some of the bank guarantee or some percentage of the whatever the goods are being exported, and finality in the suit it can be decided who is infringing, whether it is infringed product or not. Probably under those circumstances it is a quite equitable order, because the patients may suffer in the other part of world. So these are the types of very recent judgment, probably it is 1 month back. And there is something well-known trademarks. This is a concept which has been incorporated because of the TRIPS agreement in the Trademarks Act 1919 and is being incorporated, where the well-known brands are protected. Likewise, the Whirlpool case everyone knows, and several other judgments have come with regard to the Rolex watches. And these are the judgments which are given where well-known trademarks are protected. Even though that particular brand is not being used in any of the classes, that brand is protected. Now, I'll leave the slides because I got a very less time. Now, these are the judgments with regard to each subject I have just discussed. Well-known trademarks, there's the 4 judgments. Damages with regard to delay.